Good afternoon, everyone. Welcome to session 19 of the Delhi State Legal Service Authority Learning Series. Prisoners or person behind bars, their curtailment of liberty does not imply inhuman behavior to them. Supreme Court from time to time has elaborated on the rights of accused vis-a-vis Article 21 of the Constitution of India. Legal services authorities, keeping the same in view, works in the field ensuring the rights are met. Section 12 of the Legal Service Authority Act 1987 provides the category of person eligible for legal aid, and persons in custody is one such category. From early access to legal aid at police station, to allocation of cases among panel lawyers, to visit by panel lawyers to jails and police station, the legal services authorities provide free representation. You all would know that the topic for today is legal aid for prisoners. Taking no time further, I would request our member secretary, Mr. Kavaljit Arora ji, to address you as to the today's session with our resource person, Shri Alok Agarwal, and his vision behind. Over to you, sir.
Thank you. Thank you, Shreya. My dear friend Alok Agarwal ji, advisor to NALSA, dear secretaries of District Legal Service Authority, and my dear panel lawyers. A very good afternoon to all of you. First of all, I'm sorry to have kept you waiting before initiating this interesting session of learning series. In fact, before initiation of this interesting session of learning series, we had another interesting session on technology with our resource person today. So there were certain technical glitches. We have just overcome that. So welcome to this session of learning series. Though all of you are well aware regarding the wherewithal of precursor of this learning series, but for the benefit of our resource person, I would like to inform that we started this series to convert a situation of crisis to one of opportunity to build our capacity, capability, and also to refresh our knowledge so as to serve the legal aid seekers. As Shreya said, that the persons behind bar, they are one of the category of persons who are entitled for free legal aid and assistance as per Section 12 of the Legal Service Authorities Act. Friends, in order to achieve our motto of access to justice for all, we at Delhi State Legal Service Authority, we follow the Charter of Magna Carta, which says that to no one will we sell, to no one will we deny or delay right or justice. And for us, what justice is? Justice is doing something for others that we would want done for ourselves. Friends, justice, social, economic, and political, is our constitutional pledge enshrined in the preamble of our constitution, incorporation of Article 39A in the chapter of Directive Principles of State Policy, created a positive obligation on the state to ensure that on the basis of equal opportunity, that equal opportunity be provided to each and every citizen, and free legal aid and assistance is provided. And to do so, and to achieve this particular object, Legal Services Authorities Act 1987 was enacted by the legislature. Implementation of this act has become a powerful weapon to ensure right to legal aid in India. Section 12, which Shreya was just mentioning, it states that legal aid will be available both on means test as well as on merits test. If we go by the class and category of persons who are entitled for free legal aid and assistance, that constitutes about 85 to 90% of the population of our country. The legal aid extends its support to litigants with special requirements, and that includes all those persons who are in custody, all those custodial prisoners. They are one of the categories who are entitled for free legal aid and assistance. Friends, effect of setting of national, state, and district legal service authority on the people had been immense. These authorities at national level, at state level, and at district level, they provided flesh and blood to the statutory and constitutional rights of all those persons, all those classes and category of persons who are enumerated in Section 12 of Legal Services Authorities Act. और ये हमारा collective effort है. It is say collective effort of judiciary, state, panel lawyers as well as paralegal volunteers, जिसने इंडिया को वर्ल्ड का बिगेस्ट लार्जेस्ट लीगल एड सर्विस प्रोवाइडर बनाया है. There is no other country in the world which provides or which caters to 85 to 90% of its population for providing free legal aid and assistance. India is the largest service provider of free legal aid and assistance, and it is possible only because of the collective efforts of all of you. State, of course, is involved in that. Center is also involved in that, and you people being part and parcel of our authority are the main pillars of our strength. So if we take, अगर मैं recent example की बात लूँ, which emerged owing to the COVID-19 pandemic, Honorable Supreme Court, in order to decongest the overcrowded jails and to ensure that principles of social distancing, they are adhered to inside the jail premises so as to prevent the outbreak and spread of coronavirus, directed all the states to constitute high-powered committees. Friends, इसका purpose Honorable Supreme Court का to constitute high-powered committee was only this, that these high-powered committee shall meet and shall decide the class and category of persons and shall recommend that this particular class of prisoners, under trial prisoners or convicts can be released on interim bails and parole. So high-powered committee so constituted in Delhi, it met on number of occasions and it gave several recommendations directing a particular class and category of persons who can be released on interim bails and paroles. UTPs on interim bails and convicts on paroles. Though in none of the minutes of all these meetings of high-powered committee, it was denied that private counsels cannot file applications for their custodial clients on the basis of the criteria defined or promulgated by high-powered committee. But practically, if we see that basically it is you people, it is the councils, panel councils of Delhi State Legal Service Authority who practically filed all the applications for interim bails of the inmates, jail inmates. Though this has given an occasion to executive bodies of various bar associations of Delhi to raise unnecessary and uncalled for complaints against our authority that private counsels could not represent their clients, and all the cases have been taken up by Delhi State Legal Service Authority. But Honorable High Court did appreciate the contribution made by all of you. Honorable High Court did not took it as complaint, rather it was taken as a compliment that Delhi State Legal Service Authority, representing so many under trial prisoners and convicts, got them released on interim bails and parole, and during this period, say more than 4,000 persons, jail inmates, they were released on interim bails and paroles. It is definitely a tremendous success. It goes a long way in the achievements of Delhi State Legal Service Authority, and it could be possible only because of all of you, the efforts made by all of you at Delhi State Legal Service Authority, following the mandate of NALSA of not only ensuring free and competent legal aid to the prisoners, but we are also providing our services at a stage which is as early as arrest of a person. As Shreya was telling, we have a roster of our panel lawyers who are available on call for each and every police station of Delhi. Our panel lawyers, so deputed, have a mandate that in case they find कि कुछ ऐसी personal necessity है, कुछ ऐसी requirement है in a particular case, then they can visit the police station, of course against a prescribed fees which shall be paid to the panel lawyer by our authority. Then at remand stage, during investigation, during trial, and even for filing of appeal in cases of conviction, free and competent legal aid is provided. I would like to mention with pride that all our panel lawyers are not only competent and efficient, but they are also dedicated and devoted to the cause. Your regular jail visits and other duties which were assigned to you during this lockdown period and thereafter, that in it when other persons they were sitting in the realms of their respective homes is an exemplary proof of your dedication and devotion towards the marginalized sections of the society and of your true allegiance to our authority. So I'm really very proud of you. Friends, we have chosen this particular topic for today, prisoners' right to legal aid. In order to know more about the same, what are their other rights which have been given to them either by the statute or by different government policies uh, uh, which have been promulgated by the state or the center. NALSA had been coming up with various objects and projects on this particular topic, and idea and force behind all these topics and projects have always been my dear friend Shri Alok Agarwal, who after giving 5 glorious years to NALSA as member secretary, has demitted the office on his superannuation. However, acknowledging his contribution and work to NALSA, he was not relieved, he was not allowed to leave NALSA and has now been appointed as advisor to NALSA. So he is still attached. We are fortunate to have him. So legal aid, what I feel that legal aid just flows in his arteries and veins along with his blood. So I, without taking any further time, shall request Shreya to formally introduce and invite learned eminent speaker for the day. Thank you. God bless you. Over to you, Shreya.
Thank you, sir. So, sir has already said that to him, the legal services goes in deep. And when you discuss with him the kind of zeal Alok ji has, and he kind of inspires you to work at the community level, is worth the mention. Sir has held various important courts in his tenure as in the judicial career. He has also been additional director, Delhi Judicial Academy, and I'm very privileged that he was the director at that time when I was undergoing training, and I have been his student at the academy. And sir has been, as stated by Kavaljit sir, he has been in NALSA for 5 years, and the way he knows how the practice needs to be done and how the legal aid lawyers, the paralegal volunteers, and judicial officers, how they together as an institute can take the legal services authorities ahead. He's the one who has made all of us learn, and we are very privileged that he's amongst us to share with the lawyers of Delhi the vision behind and to speak over the topic legal aid for prisoners. I would request Sir to take over now. Yes, sir. Over to you, sir.
Thank you very much, Shreya and Kamaljeet. And my compliments to the two of you, everybody at Dslsa, for organizing this lovely learning series. Today, I'm told this is the 19th episode. I watched a few episodes earlier, and for me, it was quite a good learning experience. Today, I'm very happy to be interacting with the lawyer friends from the panel of the Delhi Legal Services Authority, although it's virtually, but this has given an opportunity for us to interact. I must also compliment them, compliment all the participants for the uh, for the way they have been actively participating in all the this episodes of the learning series week after week when everybody is under lockdown. I have other reasons also to compliment DSLSA, its district secretaries, staff, panel advocates, and paralegal volunteers. The way you people have worked during this lockdown uh, for decongestion of courts, as Kamaljeet had mentioned, 4,000, getting out 4,000 prisoners, filing individual bail applications, arguing them, and getting them out is no mean job. Then paralegal volunteers and maybe under the guidance of panel lawyers have been helping the administration in food distribution, in identifying people in need, whether they were migrant labor or other people who are stranded, and especially those working the helplines. They have been doing a marvelous job. I would say that this is what probably Roscoe Pound meant when he said law is social engineering. Coming to the legal aid part of it, You see, the legal aid system in India is unique in many ways. We all probably know that. The two main features of its uniqueness are, which you won't find anywhere else, are the wide range of services that we provide. We don't stick to legal representation in courts only. We are creating legal awareness amongst the masses, going up to the remotest places, telling them about their rights and about their entitlements under various government schemes. We are connecting them to the entitlements directly, and the kind of so many other services, Lok Adalats, our indigenous method of ADR. Second is the range of the people, of the categories of people to whom we provide this service. Believe me, nowhere else in the world, as much as 80% of the population, that we have a huge population, would be entitled to free legal aid, as they are entitled here in India. As many as 12 very broad categories. And one more thing, if you see in other jurisdictions, most of the time you'll find in some cases, some countries legal aid is available only for civil cases, in some countries only for criminal cases, somewhere it is criminal cases which are punishable with a very heavy punishment, life imprisonment or so. It's only in India that these 12 broad categories, which constitute 80% of the population, are entitled to all the legal services free of charge. One of those categories, that a very important one, is persons in custody. It can be in jails, whether if it is in jails, it can be as a under trial, as a convict, as a remand when somebody goes in at remand stage. It is in juvenile homes or any other kind of custody, including protective custody. They are all entitled to free legal aid. Why? Why it is not limited to, say, there is no means test here. Why in India there is no means test, and why it is for all the prisoners who are in? Because that is supposed to be the one of the basic principles of fair trial. Everybody is entitled to legal representation, whether of a lawyer of his own choice, and if he can't afford them, a lawyer provided by the state. So all prisoners, any kind, are entitled to free legal aid from us. Now we'll be talking about prisoners. I feel that any discussion about prisoners may start with asking ourselves one basic question. It's not a quiz, it's the question has obvious answer which everybody would immediately come out with. So it's not sort of testing anybody's mind. What is important is that we ask this to ourselves and the answer flashes in our mind. The question is, what is common between a professor, a judge, a lawyer, a bank clerk, a beggar, and a thief? The obvious answer is they are all human beings, rights bearing human beings. All of them have, they are not devoid of the human rights or the fundamental rights. So, how a person in custody, whatever offense he has committed or is alleged to have committed, how he has to be treated uh, while he is in custody, it all comes from two basic postulates. Two basic principles we have to remember in mind, from which all the rights that are documented so widely have arisen. One is that human rights are not lost just because somebody is in custody. You can't put any more restrictions than are absolutely necessary and absolutely incidental to incarceration. Second principle is that uh, the main objective of punishment is not retribution, but is reformation and rehabilitation. Uh, all the rights of prisoners ever since this rights talk has started, we have had in India, we have had A.N. Mullah Committee, which gave its report in 1980s. Even the Prisoners Act, the old Prisoners Act of 1894, I think, that also recognized some basic rights that they cannot be. I mean, there was they cannot be punished more than what the punishment has been given to them. There should be separate accommodation for males and females, for youthful offenders, and for other adults. So certain rights were recognized even at that time. Then we had the A.N. Mullah Committee report. In the meanwhile, there was a UN declaration in 1990 of the minimum standards of minimum principles of treatment of prisoners. This and the Mullah Committee report gave uh, rise to a model jail manual, which was a compendium of all these rights and the practices to be followed so that the rights are availed. The jail manual has now been revised. The latest revision is in 2016. Other states have come up with their own jail manuals. Some of them are based on this 2016 model manual. Some have different provisions also. Delhi, incidentally, has come out with a very detailed jail manual in 2018. Now, we'll not go into the theoretical discussion about all the rights. These rights are well documented. We'll talk about a few of them, which we as legal services lawyers get confronted. Now, every year, if you see the crime statistics report for NCRB, about 18 lakh persons are arrested and remanded to custody, judicial custody. At any given time, there are about 4.5, 4.6 lakh prisoners, out of which 71% are under trial prisoners. 71% is the latest of 2018 statistics, and the remaining 29% are convicts. Now, of course, the reason for there being more under trials than convicts could be the usual delay in criminal trials, which is a topic of separate discussion, and it cannot be here today. But it may lead one to think at least, why at all should people be sent in for very short terms? You see, 18 lakh arrested, 4 lakh are there. So 14 lakhs have come and gone. This keeps on happening. And most of the time, uh, I don't remember the percentage right now, but as per the crime statistics, there was quite a good percentage where the people have been in for less than 3 months. Short-term punishments don't do any good to the future of a person. So it is just a question to think about. Why should say the things like expressions like investigation is pending, the investigation is at a nascent stage, let the charge sheet be filed. Why should these be lone grounds for remanding people to custody? That's a matter to think about and maybe argue in the court whenever time um gives you the opportunity for that. But given the situation, given the system, what can be done and what are our responsibilities? We'll go into this now. In two categories, I would say. One is what is our responsibility when the persons are inside the jail? And secondly, in what ways can we help prevent people going to jails? I'll take the first broad category first. What are our responsibilities for the persons who are inside the jail? The first thing that comes to anybody's mind as a legal services institution would be that that we have to ensure that everybody has legal representation. Second would be that that's our responsibility to create legal awareness amongst the people. Awareness in respect of their rights, awareness in respect of the proceedings in their cases, and awareness about the ways to conduct in the prison and how can they earn releases which are lawful releases. Third thing, which is our responsibility, is to then, after creating awareness, do everything to help them to avail these rights and entitlements. So these are our. We'll take the we'll take them one by one. So far as the right to legal representation is concerned, you see, Ajmal Kasab judgment says that it is the duty of the court to ensure that everybody has a legal representation. So the duty of the court, courts have to ensure that. But since we are the ones, the legal services institutions are the ones who have to provide legal aid to everybody, it falls on us also to see to it that nobody goes without a legal representation. Legal representation is given at remand stage, then it is at trial stage, and then in appeal. One difficulty, remand advocate, we give it through remand lawyers, and the trial and appeal, we appoint them individual lawyers. Now, when a person goes to the jail, he is asked whether he has a lawyer of his own or he wants a legal aid lawyer. It is supposed to be the duty of the jail superintendent also to ask him and record that. Now, the new Delhi jail manual specifically mentions it as a duty. Then we have legal services clinics in the jails. We have paralegal volunteers, convict paralegal volunteers, who are supposed to contact the people, the new entrants, have a chat with them, know about their requirement of legal aid, inform the lawyer, and so that it is communicated there. But I find a bit of a difficulty here, and I would request Dslsa, Mr. Arora, also to tell us later on if this has been overcome in Delhi, or what can be the ways to overcome this. The problem is that when the jail superintendent asks him whether he has a lawyer or not, suppose he does not have a lawyer, and then there is a subsequent remand, then there can be 2-3 remands also. The legal services institutions do not appoint a permanent lawyer or an individual lawyer to people when they are at the remand stage. They are represented by the remand advocate of that court or whoever is present to represent them at that stage. So here, I mean, I'm saying this also because some research reports that I read earlier had objected to this practice. They had said that no, the same lawyer should continue and all, which we in NALSA we found it difficult to implement, mainly because people are there for short term. Now, tomorrow he'll get bail. So you can't have lawyers appointed for everybody unless the trial at least starts. So, I mean, this is a little bit of an anomaly that I find. So primarily, the duty to ensure that legal representation is there for everybody. Out of the legal services institutions offices, it cannot be with the jail visiting lawyer. It has to be with the DLSA office and the courts. The DLSA office, which is in the court, the office has to keep inquiring and keep in touch with the courts, that everybody, and to remind the courts that it is their duty also that nobody goes unrepresented. Now, representation, suppose we are able to give representations to everybody. The second thing comes about quality of representation. We have been, at NALSA, we have been emphasizing on this for a long time. Actually, here, since I am addressing Delhi panel advocates, I'm happy to say that probably Delhi is the only place from where, about the panel lawyers of Delhi, about whom I had heard from a very senior judge. I had heard a very senior judge, now a very senior honorable judge, and now in the Supreme Court, that Delhi panel advocates, especially in the High Court, he has generally found better than the other private lawyers. So that's a highly complimentary thing. I mean, it makes one swell with pride to hear this. But otherwise, we all know that the perception about our quality is not really very complimentary. I'm not saying that the quality is not good. Even if it is good, somehow that perception continues to grow. That legal aid lawyer है, ठीक है, argue. Now lawyers also say, जी argue क्या करना है, legal aid से हूँ. So that kind of negative perception still prevails. May I give one suggestion for this? You see, what happens is, and we have to accept one thing. Most of the time, what happens is, when does the client who comes from the prison see us for the first time? Most of the time, it is when he's in the accused box. There is a witness in the witness box, and we get up to cross-examine the witness. We have never talked to that person before this. You might have read the charge sheet. You may be very thorough with the charge sheet. You may be knowing what to ask in cross-examination, what are the weak points. You may have even got the story from his relatives. But to give him the confidence, it is absolutely necessary that the lawyer talks to him at some point of time. You see, in the Supreme Court, we all probably know that before a legal aid lawyer, or before any lawyer whose client is in jail argues an appeal, he needs to show a certificate to the court that he has talked to his client on video conferencing from the court premises, the Supreme Court Legal Services Committee's premises. This may not be feasible all the time in the district courts. So, but having a discussion with a lawyer, you may have made out a very good case for him. He doesn't know. Probably after the whole thing is over, he may not know what transpired between you and the court. He may not understand your language that you talked in. And this you'll acknowledge. होता क्या है, ऐसे ही होता है ना. Witness है, is there, we know what क्या करना है. पुलिस वाला है तो we ask him कितने बजे वहाँ से पुलिस स्टेशन से चले थे, क्या एंट्री की थी, कितने बजे कहाँ पहुंचे, किसने कौन से कपड़े पहने हुए थे, that's all. My suggestion in this is, maybe even the private lawyers are doing that. I'm not distinguishing in that. But since it is our perception which is somehow going down, my suggestion is that all panel lawyers, every time they represent a client, may seek a formal permission from the court to talk to their clients for 5 minutes before they appear for him. You talk to him, though no court denies the permission. It will have two effects. One is client satisfaction. Once you have talked to him, whatever he has told you, you may be, even if you argue the other way there, you can always tell him by ishare se ki, it's okay, I understand the case better, this is better for you. He'll understand. Otherwise, he will not, if you have not talked to him directly. Second advantage is changing the perception. The courts will know that, the lawyers are not just perfunctorily doing their job. And the general public, the others will also know. So legal representation in the courts should not be and should not seem to be a routine perfunctory exercise. If we just start doing this, I have I have an inclination to believe that it will start changing the perception about this. Now, this was about legal representation. Second is, that's our main job. Well, that's also our main job, what we call creating awareness. Legal awareness about the rights of the prisoners, awareness about the information about the cases they are their pending cases. In Delhi, there is a huge advantage. The biggest problem in all other states except Delhi is that we are not able to tell the prisoner as to what is the next date in his case, and that's what he wants to know. What had happened on the previous date, and when is he supposed to go to the court? What is happening to his appeal? In Delhi, the information kiosks, I am told, they connected the prison management system with the CIS system, and you get all the information about the prisoner's case. So take advantage of this. This is a very good provision which is not there anywhere else in India, so far as I know. So this our legal services panel advocates should actively assist the prisoners, get their information from the out of the kiosk, and if possible, have copies of them. Actually, the Delhi Jail Manual 2018 has a specific provision for this, that all the prisoners are entitled to have all the copies of orders passed in the litigation, and whatever has transpired in the litigation. Better still, if it is possible, although it's difficult, to have all the information recorded somewhere in a register or on the computer in the jail clinics. It is difficult, I know, because of the short-term periods that some people usually come in. So often a jail every day the inmates change, so it may be difficult to keep that record. But so far as possible, let's try it. Then legal awareness about the rights of the prisoners. Rights, if we say about the court proceedings, so one thing was the information about the cases. And then there is a right to be produced before the court on due dates, either physically or through video conferencing. There is a right to the to legal information about the detention and release provisions. We have to actively keep telling the prisoners about the conditions of and the right to bail, release on parole, furlough, about the and bail. When I say bail, for bail under section 436A CRPC, we'll have to keep track of the periods of detention. You see, the National Prisons Portal, probably the Delhi prisons have this on their portal, they have the dates correctly. But the National Prisons Portal, which is run by NIC, they had started mentioning the number of prisoners who are entitled under 436A or who have crossed half their punishments on their dashboard of the portal. But later on, they found that it was not tallying with the actual records and they removed the information. So this track has to be kept of their period of detention. Release about parole and furlough, whoever is eligible after a minimum period as is defined in the manual. What conditions parole can be obtained? What conditions furlough can be obtained? Should the prisoner do to have that? Then there is filing applications for parole and furlough. And in this sequence, the next thing comes remissions. We have had recently the news that one of the prisoners who was repeatedly earlier denied remissions has now been finally released, Manu Sharma, on bail. So a continuous effort will have to be made. This needs legal representation. This needs he needs your advice and the applications being filed by you. Another thing could be if of a long-term convict, the facility of the option of open jails is there. So we should keep telling the prisoners as to what conditions they have to fulfill so that they can qualify for open jails. The provisions for appeal for the convicts, review and revision. So these are the rights about legal proceedings and including the release and all, mainly, which you see we have once again the jail manual of 2018 has a provision that of holding regular legal literacy classes. So we are already holding classes, holding legal literacy camps and other programs and campaigns and everything. I would suggest that if it can be or in an organized manner, successive uh, on successive topics and awareness for everybody, all the prisoners, all the inmates of the jail, maybe through video conferencing also it's possible. Because what happens is that today you tell one set of people about something, maybe in another set of people are more needy of that and they may not come to know of this provision. So the important thing is that have a systematic legal literacy programs, seek their queries, seek whoever thinks he is entitled to whatever relief, help them get the relief, keep following up. So this is the way we have to go about if we for fulfilling this mandate of creating legal awareness about the court proceedings. Then general, if you take up any of these compendiums of the prisoners' rights, there are a number of rights emanating from the same two postulates that I talked about. Adequate accommodation, the issue of overcrowding, we have all heard it's being raised time and again and in all platforms. Overcrowding is actually it's a huge issue, and Delhi also are the jails are very much overcrowded. But this is not an individual to individual issue that we can take up in the court for a particular individual. As a class action, PILs have been filed and are continuing, and orders have been passed, and they are being implemented also, but it will take time. So we cannot do it we cannot go for it on a particular individual. The other rights should have adequate washing and bathing facilities. Now, there are number of and the other things are number of judgments on physical torture earlier, when right from Sunil Batra, when that was more prevalent. Now, hopefully and thankfully, physical torture is we don't hear much complaints of physical torture. Although, if you recently some web series, the jail conditions were shown, and one could really get appalled by seeing what kind of mental harassment a person can go through in case the jail authorities don't take care. So then there should be adequate healthcare and medical facilities. Once again, Delhi is lucky in this regard. There's not much of a problem, but in many other jails in the country, that facility is very severely lacking. The prisoners have a right to preservation of their dignity, right to profess their own religion, right to have connection and communication with their relatives and friends. They have a right to education, vocational skills. All these things are, I feel, best told to them systematically, one by one, in the form of a course curriculum, and any complaints arising of violation of these rights have to be heard individually and applications filed wherever necessary. So, apart from these are the general prisoners that we were talking about. We'll talk a little bit about the special categories of prisoners also, like women. They have separate rights declared under the statutes as well as by some judgments. The children up to 6 years living with their mothers in the jails. About 2 years back, NALSA and all state authorities conducted a campaign for women prisoners. And out of the 18,800 women prisoners in all the jails, about 14,800 were personally interacted with. Out of them, 641 were identified as having mental health issues. 5,000, more than 5,000 women prisoners were connected to vocational training. Their children were admitted to schools. We all know the R.D. Upadhyay's judgment in 2006, where some of the detailed guidelines were issued by the Honorable Supreme Court, especially about the children living with their mothers. And first of them was that wherever it is possible, a temporary release of the woman when she delivers a child or a pregnant woman on parole may be considered. Then, of course, the adequate nutrition and adequate medical facilities have to be provided for the children, and there should be a creche and nursery attached to the prisons. And one important direction there was that whenever a child is born in the prison, the no document can have this mentioned, the the place of birth or the address of the mother as the prison. Uh, Address of the locality where the prison is situated can be given, but it should nowhere be mentioned that the mother is in the prison. So these are some important guidelines for women and children that we must tell the women prisoners, make them aware about it, and if they have any complaints in regard to that, then take up the matter with the authorities. Second is the mentally ill persons. Now, the very famous Machang Lalung case, where the person with mental illness, everybody forgot about him, and finally he was located, and his release could be secured after 45 years of his incarceration. Stopping of trial when somebody is diagnosed with mental illness is mandated by the CRPC, and it is also mandated that he has to be shifted to a mental health facility. The Right now, the Delhi jail manuals is specifically mentions this. It's rule 1121 of the Delhi jail manual of 2018, that persons who are having mental illness have to be shifted to mental health care facility established by the government. There is a provision in the Mental Health Care Act, the recent one, uh, section 103, which says that the government is mandated to create a mental health establishment with in the medical wing of at least one prison in a state or in a district. So otherwise, they have to be, if that is available in the prison, then normally, if he doesn't require real institutionalization, then he'll be taken care of in that wing. However, if the institutionalization is required, then he has to be shifted to the mental health care establishment, and he cannot be kept in jail. Third category of special category of prisoners would be death row prisoners. There have been the controversies have arisen earlier and recently also about the rights of the death row prisoners, about when it should be final that day, the date of the hanging should be finalized. So the prisoners should know about their rights in this regard, and the lawyers will have to take proactive action in making representations or petitions or whatever is required on their behalf. Especially the rights when he is convicted and sentenced, right to an appeal, right to file a review or a curative petition in the Supreme Court. Then there's a mercy petition. Uh, this thing, time is required before that order is final. And most important is that should be able to exhaust all his remedies before the final hanging takes place. Lawyers are the guardians of these rights. We have seen the lawyers in the recent case fighting ferociously on this, and in this regard, I would say they've done a good job. So, as legal services lawyers, it's our responsibility also that we have that in case we are interested with such a matter, we find in the jail, we should ensure that all legally available remedies are actually exhausted. Now, foreign prisoners, the main issue is consular access. So they should be aware that they are entitled to consular access. The prison authorities should be sensitized uh, to provide them consular access, and the consulates or the high commissions. They have to be there has to be communication with them to provide relief or to be in communication with the prisoner. Another thing about foreign prisoners is that sometimes they may be some that they may not be able to understand the language, and an interpretation and a translator may be necessary for them to understand the important proceedings. So this also is their right, and we have to make applications for that. One more suggestion that I have in this is that maybe a special uh, campaign for them about the Indian legal system, about the Indian laws, especially the laws in which most of them are booked, and the procedural laws. So that will help a lot, and this reinforces their faith in the Indian judiciary and the judicial system. What we have talked about now was the how to deal with the persons who are incarcerated. We also, let's see how we can help prevention of incarceration. See, there are unnecessary after sections 41A to D. There are a lot of conditions required before you arrest a person, up to when he's alleged to have committed an offense up to 7 years. Now, Section 41A up to 7 years, then there have been judgments right from Joginder Kumar, D.K. Basu to Arnesh Kumar. But still, if arrests are routinely made, there is a criticism in the press also, and in some NGOs reports, that a lot of unnecessary arrests are made. As we saw, 18 lakh people arrested in a year, and finally we have a couple of lakhs convictions at the end of the year. So that is mostly, much of that could be unnecessary arrests. But so unnecessary arrests, as Mr. Kamaljeet was saying, we have this NALSA's protocol for early access to justice, where you are available on call when the person is brought to the police station and interrogated. Now, Section 41D, I think, specifically provides for this, that he can have a discussion with a lawyer of his choice. Lawyer of his choice is, if he doesn't have his own lawyer, then you are the lawyer of his choice. So, your frequent visits to the police station advising the clients will also, by and by, sensitize the police officers. You will tell the client about Section 41. It goes to the police, the investigating officers also. And I'm hopeful that this will slowly reduce the unnecessary arrests. Second thing in this is, you see, it's not just by arresting the person doesn't go to jail. He goes to jail when there are unnecessary remands. We have remand advocates in the court. If the remand advocates can prevent unnecessary remands, that will be a big help. As I said earlier, I would request the advocates, remand advocates, to kindly, every time when there is a person produced in custody for the first time. For the first time, we'll talk first, and he is to be remanded. Every time, please ask the court to give you 5 minutes to talk with the client, and then make your submission. See the remand papers in front of the court. Once again, it will give an impression to the court that you see, it has the when somebody comes for remand, it is not a perfunctory exercise. Unfortunately, courts also have been usually, in many states, remanding the people without even looking at them. So once a legal aid lawyer, and all legal aid lawyers, all legal services lawyers as an institution, start doing this every time, start telling the court, start asking the court that we want to talk to our client, and then talk, and then represent, then argue about him. This will slowly change the culture of perfunctorily giving remands. This was mainly for the first remand. Now, what happens when in subsequent remands? Subsequent remand, the role of remand advocate is equally important at subsequent remands also. It's of course a routine matter that once somebody is remanded for 14 days, then 14 days goes up to the period, the total statutory period. One request is that count the number of days that are left before he is produced the next time. After the 46th day or the 76th day, as the case may be, in the offences of up to 10 years or more than 10 years, there cannot be a remand for 14 days. The remand has to be only for the remaining period. So if it is person is produced in the 50th, on the 50th day in the court, the remand has to be for 10 days only. Because if he gets, this has to be vociferously argued by you in case the courts are giving 14 days remand. Why? Because if he is remanded for 14 days, he goes back to the jail, he doesn't know 167.2, there's nobody in the jail at that time to tell him 167.2. You don't know, you don't keep a track of, because it's not may not be possible to keep a track of everybody. As to when 60 days are getting over, nobody will file a bail application, and an important right will get lost. So please ensure that he gets produced on the 60th day and the 90th day, wherever applicable, file applications under section 167.2. One more thing about prevention of unnecessary incarceration would be at the time of sentencing. The Probation of Offenders Act is very highly underutilized in India. We may say that there are, there are very few probation officers and all these things that we keep on thinking, but it's a statutory provision. Uh, Once a person, a first-time offender, say doing any offense, it may be any offense, first-time offender, but if the offense is punishable with less than 7 years and is otherwise admissible under the Probation of Offenders Act, probation has to be the norm. It is not a good argument that because these type of matters are on the rise, so he cannot be given probation or things like that. First time offender eligible under Probation of Offenders Act has to be given probation unless there are very exceptional circumstances. Please start arguing this every time there the matter is kept for argument on sentence. You see, because once again, when we find that the convicts that go to jail, many of them which go for short terms, short-term imprisonment has been totally abolished, abandoned in many jurisdictions. There is community sentencing, there are deferred sentences, there is a high fine and a staggered fine, lifelong fines in place of in place of small short imprisonments. Even at the remand stage, rather than sending him to jail for remand, there are other methods used, reporting to the probation officer every day, ankle tracking devices are there, because short-term imprisonment is not considered uh, to be good for anything for the life of the prisoner. So we as legal services lawyers can try to minimize this by vigorously arguing for probation wherever this occasion arises. That's probably all that I would say today. We have discussed the thing that we can do given the system, and which are our basic duties as legal services lawyers. I've not gone into too many details of the rights because they're all documented and we can read them anywhere. Thank you all very much for listening patiently, and any queries, any comments are there, they're most welcome. Thank you.
Thank you so much, sir, for patiently taking us from one step to the other, how the Legal Services Authority function and how, as an advocate, one should take care. I think it was very, very interesting session, not only for lawyers, I'm sure for all the secretaries too. So thank you so much, sir. Sir, the question first and foremost is by Advocate Shivam Singla. He says that under trial, incarcerated prisoners challenges our democratic values and adversarial system and is violate of due process of law. Should not judges make police authority liable for delayed investigation?
You see, delayed investigation, these are all, you see, the problem is that the statute allows this. The CRPC, they give you times are fixed for investigation to keep you in custody during investigation. Otherwise, limitation is prescribed only for petty offences, not for other offences. There may be good reasons for that, especially when you can unearth some evidence after a long time. Uh, that should may be required, but certainly in some cases the limitation, some more cases the limitation should be provided. That's my view. But the thing is that it's a statutory thing. So if it's a statutory discretion, then it's difficult to formally penalize somebody.
Yeah, truly, sir. We understand. So, sir, the next question I would just put it to you. So it's by Kajal Chand. Whether under Section 304 of CRPC, Legal Services Authority will appoint a particular high-profile advocate as desired by accused, or another advocate will be appointed whose name is in the list of the authority.
This is the discretion of the concerned state and district legal services authorities. Our NALSA's advice to them has been that appoint lawyers as per the requirement of the case. There is a recent judgment of the Delhi High Court now, that Delhi High Court or Supreme Court, I don't remember, that for cases of life imprisonment and murder and all, uh, so far as possible, senior advocate should be appointed. So senior designated senior advocates at some places, and most of the places we have, even on our panels, we have advocates more than 10 years of practice. If a case is complicated, then you cannot go, the authority, the district secretary cannot go by the alphabetical list. It has to be as per the merits of as per the complications of the case and the capability and experience of the concerned advocates. And this is a subjective thing, but it has to be there. There's no other way.
Sorry. Thank you, sir. So another question is again by Shivam Singla. Should the Honorable Courts of India strictly follow Section 41 CRPC? And with Joginder Singh versus State of UP and Anesh Kumar judgment of Supreme Court to solve this challenge?
You see, Section 41A to D have been added. Up to 7 years imprisonment, you have to give a notice. You can't arrest a person directly. Then you have right to legal aid. So this is all statute. Who has to follow it? It's the police officers and the courts have to follow it. No.
True, sir. Sorry.
Although it blurs up one part. Okay, if you have asked me, let me say this. See, earlier, if you have a point where anybody who has committed an offense, the police goes to him, he interrogates. First thing they used to do was arrest him and interrogate. Right now, of course, it's a very good safeguard that that they should not be arrested every time unnecessarily. But the thing is, another complication can arise out of this. Now, this gives the police a license to call him every day, keep him in the police station, keep interrogating him every day, with no need to produce him before a magistrate. This is a prolonged interrogation, and you have judgment saying that that interrogation is custody. So it's a otherwise I mean, I don't know if the situation is arising like that. I hope it doesn't. But theoretically, there is a possibility.
True, sir. So I think this would be the last question. I cannot see any other question coming up. That's what if prisoner is not satisfied with advocate's performance for his trial and wants to get him replaced? Then what is the remedy available as he was appointed by Legal Services Authority?
Legal services authorities can replace him, but it's they have to see whether he should be replaced or not. You see, my perception of something may be different from your perception. So you have to rely upon the subjective discretion of the Legal Services Authority on this.
Sure. So I will now open our member secretary too and for his concluding remarks. 1 second, sir. He's right here. Right, sir.
Thank you very much, Alok, for such a wonderful and interesting session. And the points which you have made, they were not only for our panel lawyers, but for us as authority also. And I assure you that all the points which you have made, they have been well taken, well noted, and we would be working on that. You are absolutely right that though we are making sure that every person or no one should go in the court unrepresented, and every accused. The points you have made, they were not only for our panel lawyers, but for who is produced in court is represented by a counsel. As you said that even at remand stage, we should make sure that a lawyer is appointed to a particular accused and he continues to remain with him throughout that remand stage till the time the charge sheet is filed. So we would work on the feasibility of this particular aspect, that whether it is possible for us to depute a lawyer at remand stage and remain with that person who should remain with that accused during the entire duration of remand. And apart from that, the other point which you made, that client satisfaction and change of perception, public perception, as well as change of court's perception. So in this regard, we already are having the refresher courses with our panel lawyers, and we have told them that before, say, representing a particular accused to whom you have been appointed in court, you should talk to that person. You should be moving appropriate applications before the court for the purpose of taking permission to talk to the accused. And you are absolutely right that This way, it gives a lot of satisfaction to the under trial prisoner, to whom we have deputed that legal aid counsel, and also to the court. So we would definitely see to it that all our panel lawyers, while representing an under trial prisoner during court proceedings, they do file applications in the court and take adequate requisite permission from the court to talk to the client before, say, starting arguments or before starting cross-examination of the prosecution witnesses. Then another point which you made regarding legal awareness, also legal awareness in jails. But let me tell you that we are having regular sessions of legal awareness in jails. We have deputed our paralegal volunteers who are regularly in jail, and apart from that, our secretaries, all the secretaries have been assigned different jails, and they are visiting the jails for the purposes of creating awareness. I'll make sure I'll talk to DG Prisons, and what we will do is we will have these particular awareness sessions recorded so that they can be played again and again for the benefit of this migratory or floating population of the jail. There are certain prisoners who stay in jail for 1, 2, 3, or 4 days. So, for the benefit of these prisoners who are floating population, that these sessions, these awareness sessions, they are telecast or they are revised or they are played again and again in jail for the benefit of all those persons. Then you have spoken about the conditions and facilities inside the jail, which certainly are the rights of the prisoners, right to remain in human conditions, and then especially during this COVID period, all that common areas, they should be regularly disinfectant, and then the facilities of jail hospital and dispensaries. Uh, Let me tell you that during this entire exercise of high powered committee, apart from laying down the criteria, different criterias for or categories of persons who are entitled for being released on interim bails, we have taken into consideration the jail conditions as well, wherein this was also resolved that in jail they should have oxygen meters and all that for the benefit of all these inmates, and there should be regular, say, public awareness regarding do's and don'ts. What are the, say, precautions they have to take, and the common areas, bathing areas, kitchen areas, they have to be
Not able
regularly
to hear
disinfectant.
you.
You are not in a position to hear, Alok.
Oh,
Shreya, he can't hear.
uh, I think maybe so because your voice is very clear at my end. Maybe
No, I
so.
am not able to hear.
Anything, sir? Okay.
Hello?
Well, I think he dealt in quite a detail, maybe. But then
Okay.
the live streaming, sir, your voice is going conveniently well
To,
to everyone. I think Alok sir is not able to hear you.
okay,
Maybe.
okay.
Yeah, somehow I
Are
couldn't.
you able to hear me?
Ah, yes. Alok, can you hear?
Alok sir,
Can
are
you
you
Yeah,
hear
able
yeah,
to
Shreya?
hear
yeah,
me?
yeah, yeah. Yes,
You can
yes.
hear Shreya.
And now are you able to
मेरे को नहीं सुन
No,
cover,
no,
sir?
I can hear you, but not Kamaljeet.
Okay, sir, that could be because you're on the phone.
Yeah, maybe.
So
Yeah.
you can just because you can just swipe the thing and get sir into. Let me just sir 1 second. Let me just so just try hearing him out, please.
Can you hear me now? Alok, can you hear me now?
Sir, I think he's not able to hear you. It
I
looks
don't.
to be some glitch at his end, maybe.
Okay, no issues. But
So, I think, sir, the points you just said, I can repeat it to him. I think
Okay, okay.
now I think
So
so,
no,
basically,
there's no need.
just
I'll
wanted
watch
to
it on
I just
later
wanted
on.
to
I'll watch
assure
the
him that
recording. But
whatever he has said, they have been taken down, and whatever would be required at our end, definitely we would be doing that for the benefit and to make sure that all the prisoners who have their rights and whatever their entitlements are, they should get them and get them timely.
Right, sir. Sir, Alok sir, simple, sir. What sir has said, whatever points you've taken one by one, he said they are being met at the Delhi state level. And there are the suggestions which few of you made. He said they would be implemented from time to time. We are doing it, and we would make sure to do it with the full zeal and enthusiasm. So,
Thank you. Thank you.
so, sir, I think I would take this opportunity to thank you and my member secretary for both of you for this time for a Legal Aid Lawyers of Delhi. And indeed, a very, very informative session, very knowledgeable session. There are people who are writing, when we see the YouTube website, the people writing informative session and a different session in itself. Because this experience is only earned for the lawyers, sir, who visit the jails as jail visiting advocate. So not all advocates get to have this experience, which you have
Okay.
shared in 1 hour. So we are very, very thankful to you, sir. Thank you, Kawal, sir, for coining this idea of this session. And so we can conclude this session right away. Right.
And
Thank you.
thank you very much. Thanks a lot to both of you
Thank,
and to DSLSA for having me. Thank you.
Yeah.
thank